I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it
it
wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I checked, I verified, it is.
I accepted in return
Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want, for the
You
record,
will have an opportunity when I give you an opportunity. No one else
stated-
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This
I
court
will further
for
advise
the history of Mr. Brooks
Brooks
interrupting.
that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear, if appropriate. All right, I've received a note, we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, well, I'm not going to get off the bench. We're going to take a short recess for that resetting to take place.
I would request an opportunity to be heard then, Your Honor, when we go back on the record, please.
I'm assuming it would be fair to say that you were definitely looking at the vehicle, correct? Would that be fair to say?
When?
When it was approaching and when it passed?
Yes.
Any reason why you would not try to identify the driver?
Because my children were about to be struck.
Any reason why you would not try to see if you can catch a license plate number?
Because people had just been hit.
So it would be fair to say because of what you was observing, that would be the reason why you didn't try to get a description of the driver or the license plate.
My priority at the time was not identifying the driver.
You've seen news reports about this case in the days or the time since November 21st, is that right?
Yes.
And you've seen photographs of Darrell Brooks in other contexts, is that correct?
Objection. Yes. I do not consent to being called that name, nor do I know that individual, and he's
Go ahead, you may answer the question.
speculative.
It's not speculative.
Clearly.
Go ahead.
Yes.
The person you saw get out of the driver's seat of that SUV on November 21st, do you see that person in the courtroom today?
The
Yes.
objection is hearsay. He's speaking as a first eye-hand witness.
Overruled. I believe he answered, but could you state it again?
Yes, I see him. He's sitting at the defense table wearing a suit with a blue tie and a white surgical mask.
And just to be thorough, could we please have Mr. Brooks remove his mask for a moment?
Please. Mr. Brooks, please remove your mask. Thank you. The record to reflect the mask has been removed.
How confident are you in your identification today?
100%.
I'm not sure what the terminology for that is,
For today,
but that's how I would take it. If that's a subpoena.
No, that's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
You get something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions
Yes,
for this
I do.
witness?
Yes,
Please
I
ask
do.
them. Through one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks,
telling them the truth.
stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to a estoppel. Can you prove?
If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. We'll see you tomorrow morning. All rise for the jurors, please.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
or mixed.
Who's you?
Well, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time.
I was giving a general description.
So it would be fair to say that you weren't sure.
I was positive it was you.
Who is you?
You. I'm looking at you.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion?
Because
Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So, is it possible you saw something on the news?
No, I had no idea who you
Why
were.
is something always funny at that table? Interesting.
I
It would be the same thing. I'll take that as disrespect because they were allowed to say something, and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please?
and faces.
Admonish them
Yes,
because
I
I'm
will.
always the one
Absolutely.
getting admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with you.
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
So what other details do you not recall?
Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wanted.
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recalling.
Objection.
Don't.
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue? What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks,
intimidate.
I've made my ruling under 90611.
You said
Please ask
intimidate.
a question or
I'm trying
I
to
will
merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62Q trust, right? That you want to be the beneficiary of?
I am going to give the jury their closing instruction. We are
Abel
done with
Westcott, he has
testimony
prior
for
criminal
today.
history.
Thank you. Please do not begin your deliberation.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be said. So it's the defendant.
That's not how it was said.
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks,
So I'm the only one. I got one.
Mr.
I got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for that.
Westcott.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell?
I
can you
believe he
please-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. 70. No, I don't want to do that. Oh, you don't? I changed, hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them. Weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street, in the city of Waukesha, Waukesha County, Wisconsin.
Because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses.
And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to do.
I'm bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately
You're
being
making a record of incorrect statements. That's what you're doing. You're not making a record of not being able.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be quiet?
I'm advising you to be respectful when the jury comes out.
Are you telling me to be quiet or are you asking me?
I'm asking you and advising you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
we're all adults in here. I've never told you to do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it. So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise.
Can I get my filings?
You want the originals back. If Madam
See, I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt you.
Thank you, I appreciate that. Unless there's, I would like.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction? You knew I was about to say that.
Sir, I'm not going to address it, I already have. All right. Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
No need to get in your feelings. It's been a long day. I'm tired too.
I would agree. Procedures.
Subject matter jurisdiction, Your Honor.
I decline to address that, sir.
Will we be addressing it for the record?
All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide, recklessly endangering safety while using a dangerous weapon?
Yes.
Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 37 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 38 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey.